Hello everyone, welcome to this session. I hope you're doing well. So, in this session, we will learn about the patent process. Patent process in the sense that how an idea or an invention which is conceived in the mind becomes a patent. What are different steps to achieve a patent, how a patent application is filed, then what happens next, how publication happens, how examination happens, and how idea becomes a patent. We will discuss these things in this session. So I welcome you all to this session. Please be focused as always, because if we can't be focused, then chances of missing out something will obviously be there. So please be remain focused. uh, we will first I will briefly tell you about what we are going to discuss in this particular session. So we will discuss about patents, patent application, patent specification, different sections present in a patent application, what is a provisional application, what is a complete application, how you can file a patent application, how you can prepare a patent application, and various other information which happen in the course of when you file a patent application, and when the patent application becomes a patent, opposition, revocation, many other things. This session is such designed in a way so that if you are एकदम fresh, if you are fresh, you don't know anything about the patent thing, and if you watch this video, you will be able to understand each and every step and each and every part of the patent process. So the first thing is, what is a patent? So patent is a kind of exclusive right which is given by the patent office when you disclose an invention to the patent office. So this is a kind of quid pro quo kind of system, which means something you give and something you receive in exchange. So you give to the public or the general public invention or information about the invention, something you conceived in your mind, and you give it to the patent office, you disclose it to the patent office, and patent office will give you protection in the sense that once you file a patent application, it has become a right to you. You get a exchange, you get in exchange rights to protect your invention. Okay, so patent office gives you protection for 20 years. This protection is although limited for 20 years, but 20 years is not a small time. 20 years is a big time, large time. So patent is a legal document which government grants to you in exchange of your disclosure of your invention to the public, so that public can take benefit from it, and the process or the progress of technology starts. So what happens when somebody discloses something to another person or another people, they somehow start thinking about it, that oh, this is happening, oh, this can also happen. So improvement starts from there. You tell me something, then I will think about it, and I will try to create more advanced system to it. So this way, if this patent system would not be there, what would have happened is that people uh, people will would have kept their knowledge to themselves, because they would think that if I disclose my invention to others, they will start copying it. So prior to this patent system or patent ecosystem, I mean, prior the government was not giving any kind of protection. People think about something, they invent something, but they keep it to themselves and not disclose it to others, because others will start copying it. So they have this comprehension or apprehension in their mind that if I disclose my invention to others, they will start copying it. So to remove this kind of mentality or mindset, uh, government had decided to give protection in exchange of your disclosure of your invention. So you disclose your invention, patent office will give you exclusive rights, and if you prove that somebody else is copying your patented product or your patented process, then you can take him to the court and claim damages or claim royalty from them. You can also stop them from making, selling, and producing the patented product and patented process. So this is what the essence of the patent system. So most people don't know the difference between patent application and patent specification. So a patent is the final product or the final output. Once you disclose an invention to the public or to the government, you file a patent application. Okay, you don't file a patent, you get a patent, but you have to file a patent application to get a patent. And to file a patent application, you need a written disclosure of your invention, and that written disclosure or written document is the patent specification. So you write a patent specification, file it as a patent application, and then get a patent. If the authority or the patent office agree that your invention is new and inventive, they allow a patent. So this is the basic difference between patent application and patent specification. In a patent application, there are different sections. So when a patent application is filed, there is a title to it, you give a title to it. Then there is an abstract or summary of the invention, so that others can study the abstract, and they can get a sense, or they can get to understand what is the invention all about. This is the abstract part in a patent application. There is a background part. When in the background part, you disclose what is happening till the date according to your knowledge. I mean, you, for example, let's assume that I conceived an idea today. So I I'm able to understand that what was happening till today's date before my invention. So you will disclose that I know that this is the thing which is happening now, and this is the problem with those existing system. So background part sets out the problems or drawbacks of the existing systems, and in that background section you will disclose each and everything which is related to it. Okay, so after background there is a summary of the invention, a concise summary what is happening in your invention, how different components of the invention are present, and such stuff is being described in the patent summary. Then we have brief description of the drawings. In patent, when you file a patent application, there is some requirement of sharing drawings or images with the patent office, so that you can explain the invention in detail, and somebody who's reading the disclosure can understand what different components are there in the form of illustration or drawings. So drawings needs to be described in the patent application. Then to describe the patent, to describe the drawings or images, detailed description is written. So in respect of every uh, drawing or illustration, you need to describe what components are there, you number it, drawings are numbered, and you describe the images in detail, and that is how detailed description of invention is being created. And lastly but not the least, claims are there in the patent application. So claims are the most important part of a patent application. Specification is also important, but claims, the structure of claim, the writing, the wording of claims is very very important in that, because claims are the tools, I can say tool or instrument, which define the boundary of the protection you will get in your patent. So claims, if you write many things in claim, it will become narrower, and you will get lesser protection. But at the same time, because you are writing a narrow claim, chances are there that no prior patent or prior art discloses the same thing, and you will get a patent. So we have to create a balance between narrowness and broadness in claims, particularly the independent claims. So independent claims are searched by the patent office. So the structure of claim needs to be written in a way so that we can obviate encroachment of already filed patent application or already existing inventions, and at the same time we will have ample protection when a patent is enforced. So claim writing is a kind of art. So patent application or specification, when you file a patent application, the specification can either be provisional or complete. So if you conceived an idea and you want to protect it from the very moment you conceived the idea, you write a rough document and file it as a provisional specification so that you get a priority date. What is priority date? I mean, the day you file the provisional application, you will start getting protection for it. So let's assume that I got the idea on 1st of Jan and I filed it as a patent application, provisional patent application. And if somebody gets the exact same idea on 2nd Jan and he files a patent application for it, then because I filed this patent application earlier, a day earlier than the second person's idea, I will have the priority. If conflict comes to the court, then court will decide that the earlier filed patent application is valid and the one filed later is not valid. I mean, the first filed patent application or mine patent application becomes a prior art for the invention filed at a later date from the date I filed the patent application. So this is the benefit of filing a provisional patent application or provisional specification. What is a complete specification? So once you file a provisional application, patent office gives you 12 months time period to file a complete specification. You write everything in it in the prescribed format, the format patent office requires. You write title, background, summary, claims, advantage, drawings, etc., etc., and file a complete application within 12 months from the patent application filing date, your provisional patent application filing date. So this is the difference between provisional application and complete application, or provisional specification or a complete specification. I would like to show you a patent application I filed some time ago. So let's read it once. I will show you the application I filed some time ago. It is a patent application. It is published patent application. So let's see. I will show you different sections of a patent application. The patent application number was 3670 Del 2015, and we will exit it over this Indian Patent Office website. This was the patent application. System and method for monitoring of unique identity of a computing device. We filed it in 2015. I was one of the inventors, Lalit. and we filed it. Okay, so I will show you different sections of this particular application. This is our patent application. Patent application is filed is form 2. This is form 2 we filed, system and method for monitoring unique identities. This is the title of the invention. This is a technical field where we have described the invention, and this is background section here. These are objects of the invention or advantages of that section. Both are the same. Objects, what all things this invention can do is written in the object form. Then this is the summary of the invention. After this, brief description of drawing will come. Then the detailed description. Detailed description will describe each and every embodiment, each and every drawing of the invention. Now after this disclosure, in the end comes the claims. These are claims. A system for monitoring this blah blah blah. This is our claims. So these are the claims, and then after this, abstract will follow. Abstract. This is the abstract part of it. This is the patent application, different sections of it. So in the course of patent application, or when you file a patent application, different numbers, different date, different happenings happen. Okay, so what is the patent application number? When you file a patent application, patent office gives you a application number. This application number can be used on the website or the portal of Indian Patent Office, and you can fetch all the details of your patent application you file. That is the application number. Then the date on which you file a patent application is the filing date or the application date. Priority date. So the earliest filing date is the priority date. So if you file a patent application only in one country, then obviously the filing date is the earliest filing date or the priority date. The same date is the filing date, and the application filing date is the priority date or earliest priority date or earliest public application date. But in case, assume that you file your first application in a different country and you file subsequent application in another country also. So here the priority date is the date when you first filed your patent application in the first country. So that date becomes the priority date for the other application you file in different other countries. Because filing date in those other countries is different than the filing date of your first application. So the first application filing date is the priority date. Publication. Once you file a patent application, there are two kind of publication. One is normal publication or generic publication, where patent office publishes a patent application after 18 months. So after 18 months from your filing date or the day you file your patent application, publication happens on the website of the patent office. The way I just showed you, the application was published on the patent office website. You can access, or others can access it over the Indian Patent Office website or the website where you have filed a patent application. It is published there after 18 months when you file a normal publication, if normal publication happens. But in case you go for early publication, you have to file a form and pay some fees. In the patent office, we have to file form number 9, and you have to pay, if you are a natural person, you have to pay 2,500 rupees for early publication. So once you make this early publication request, your patent application gets published within 30 days of time. from the date you make this application for early publication. So instead of 18 months for waiting for 18 months for the publication, you will get a patent application published on the patent office website within 1 month. So you have to file an extra form and file some extra fee, and then your patent application gets published in a month's time or so. After publication comes the examination. So for examination to happen, you will have to file a request for examination. This request for examination can be filed on the same day when you file your patent application, or it can be filed at a later date. The deadline for filing request for examination is 48 months from the application filing date. So you have 48 months time to file this request for examination, but I will recommend you file this request for examination as soon as possible, because until and unless you file this request for examination, your application won't get into the queue where examination is happening. So if you want to have this examination as early as possible, you have to file this request for examination as early as possible. So once you file a request for examination, examination will happen. Examination is also of two kinds: normal examination and expedited examination. In normal examination, there is a queue where, assume that let's say 10,000 applications are filed, so there is a queue for normal examination. Your patent application will get into that queue, but there is a separate queue also which is for expedited examination, and certain special entities will have the privilege of going into that queue. So if you are a startup, or if you are a woman inventor, or if you are an educational institution, or some other entities also have this privilege. So for example, if you file a PCT application and choose India as a international search authority, then you will have the chance to be in the expedited examination queue. So for expedited examination, there is a separate queue, so only a select few number of cases get into that queue, because normal examination will happen for all the 1,000 applications, but only a few percentage, maybe 10% cases get into the expedited examination. So there is a limited set in the examination queue for expedited examination. So this way examination happens in a shorter period of time, or as early as possible. There is one more thing available which is called express examination. So if you filed a PCT application, express examination can be opted, and you can get examination done in the earliest possible way. What is abandonment of application? So if you filed a patent application and there are some formal requirements to be done, for example, you filed a provisional application but you don't file a complete application within 12 months, your application will be abandoned. Okay, and for in a different case, if you don't file a request for examination, in that case also your application will get abandoned. So if some fees are to be paid but you don't pay those fees, then in that case also abandonment will happen. So abandonment is nothing but your application becomes dead. Okay, so this is abandonment. First examination report. What is first examination report? Once a request for examination is filed, patent office performs examination for the patent application, and once they perform this examination, they will share, or they will prepare an examination report. So the first report that you receive from the patent office is called the first examination report. So if because there is first examination report, in certain cases there is one more examination report which is called SCR, or second examination report. After the examination report, I will tell you that you have to file your response. You have to study the objection raised by the patent office or the controller, and you will have to comply with the things they have asked them, or you will have to prepare response. You have to argue with the patent office that if certain objections are raised, and you have to argue with the examination that those objections doesn't stand and there is some reason or rationale behind it. So in that response you can do that. Non-patentability under section 3. Section 3 defines certain categories of invention which are non-patentable in India. Otherwise, I mean, in other countries they may be patentable, but India being a developing country has restricted certain form of invention or certain domain of inventions to be non-patentable. This is there is a section for this which is section 3, and different domain of invention pertaining under section 3 are non-patentable in India. Lack of novelty. Okay, so once you receive the examination report from the patent office, and assuming that they have identified a reference which discloses each and every aspect of your invention, I mean it is a replica of your invention and was filed earlier than your invention, and if they identify such kind of reference, so they will raise lack of novelty invention. They will say that you have copied somebody's invention and there is no novelty in your invention. It is a mere copy of this earlier filed patent application, even though you might not have copied it from others patent, but because each and everything is same or having the similarity, so they will assume that it is the invention is being copied from some other invention, so it lacks novelty. And second thing is lack of inventive step. So what happens in lack of inventive step? Now instead of one document, let's say your invention has 3 features. Your invention can do 3 things. Okay, so for each feature they will identify individual reference. So you have 3 features, they will, because they can't identify a single reference, they will disclose each and every 3 points. Then what they will do, they will come up with 3 different documents and combine those 3 different documents, prior documents, and say that each and every aspect of your invention is disclosed by these 3 references. So there is no inventive step in your invention. You have merely combined teachings from these 3 documents, and because of that there is no novelty in your invention. So in the patent FER, you will also get to see objection raised under section 10. So section 10, the requirements of section 10 is that when you file a patent application, your disclosure should be sufficiently written. It should describe the invention in such a way that others, when studying it, will be able to read it wonderfully. They not only read it, but they can, if they want, they can practice the invention. So you have to give so many details in the invention specification, the details, so that others can practice it in your invention. So if you don't do that, your specification is not clear, concise, and lacks clarity, then patent office will raise objections for the insufficient disclosure, non-clarity or conciseness in claim, non-definited claims, lacks of unity in claims. So one claim is claiming something, and the other is claiming some other thing, and there is no correlation or coherency between the 2 claims. So based on that, if the patent office feels that there is no clarity or insufficient disclosure, they will raise objection under section 10. Response to examination reports. As I mentioned earlier also, once you receive a patent office examination report, then you have to read it and comply with the formal objection raised by the patent office, as well as satisfy the examiner's objections or doubt in your response to office action or examination report. So if in the patent in your examination report they have raised lack of novelty issue or objection, you will have to give reasons why there is novelty in your invention, why it should get patent. If they have raised lack of inventive step objection, then you will have to give your arguments why your invention have inventive features and why should they allow a patent for it. So this way you have to file a response to the examination report. So even after getting your response, if the examiners are not satisfied or controller is not satisfied with your response, and if you ask them to set a hearing date is scheduled, and you will have the patent office will interview will interview with you, and both of the you inventors or the applicants and the patent office controller will discuss the invention. So after hearing, whatever happens in the hearing is filed by the applicant or the inventors written submission. There you will have to write written submission and file it with the after the hearing. What is a PCT or international application? If you want to file a patent application in multiple countries and you want to get a patent in multiple countries, but you don't want to file application in each and every jurisdiction, so this PCT application is the way forward, is the remedy to file a single application, and the same application can be prosecuted in different jurisdictions. So a single application is filed and the same application is prosecuted in different countries, and you will get patent in multiple countries. What is convention application? If you want to file patent application in 2-3 countries and you want to get into the intricacies of PCT, you will simply file your patent application, the same application you file in your home country, you can take priority of that application and file the same application in 1 or 2 or 3 different countries, and this kind of application filing is called convention application. Pre-grant opposition and post-grant opposition. Once you file a patent application, the application becomes open to the public, and if somebody from the public or maybe your competitor feels that you should not get a patent for your invention, they can raise their objection and they can file a pre-grant opposition. So before the grant of the patent, in between application filing and between the grant, they can file a pre-grant opposition. And if your patent is granted and later they come to know that you have a patent, they can object to this patent within 12 months after the grant date, and this is called the post-grant opposition. Revocation of like post-grant opposition, after 12 months have passed, you can then also object to a granted patent by way of filing a revocation petition, and the patent office or the court will assess the grounds on which you have filed this revocation petition and decide the fate or validity of the patent. So this is called revocation. If in case the patent is successfully challenged, then the patent is revoked. So these are some important things that are available, and you need to understand these when you are filing or going to file a patent application or thinking about patent application filing or patents. Then these things will come handy and they will help you in your process on your journey to file the patent application and get a patent. So I hope you have liked this video. So thank you so much for watching this video. Thank you.